Welcome back to the Recharge Zone Podcast, Season 4. We're joined here today by my co-host, Ann-Margaret. Hi, Ann-Margaret.
Hi.
And I'm Brent Doty, and we have a special guest today, Darcy Frownfelter. Darcy, how you doing?
Hey, I'm pretty good.
Glad to have you.
In our first episode of this season, Darcy's here with us. Darcy provides general counsel to the EAA, and he's done so for 27 years. Is that right, Darcy?
Yeah, that's right.
And he handles all things regarding water rights, environmental law, and endangered species, just to name a few. He's also authored numerous articles in the area of water and environmental law. So,
welcome, Darcy.
Well, I'm happy to be here. Thank you for inviting me.
I'm excited. We were talking previously to the podcast episode, and you just have a wealth of knowledge about all things water and environmental law, right? So can you tell us a little bit about your career and how you got started in water law or environmental law, and what led you to work at the EAA?
Mm-hmm. Well, that's been an interesting question. I started out as an undergrad at A&M as an architecture major,
really?
Of all things.
And, I didn't know that.
And during my studies at A&M, this is back in the 1970s, the environmental movement was getting kind of hot and going, and I kind of shifted my focus from the design of buildings to the impact of the built environment on the natural environment. Mm. So about halfway through my architecture studies, I decided to make a major shift and go to law school.
Wow.
We actually had a couple of visiting folks come and speak to our classes, and I noticed, hey, a lot of these guys are lawyers.
Uh-huh.
And so I ended up shifting my focus, and, back in those years, the Pacific Northwest was where things were happening environmental law-wise, so I applied only to, a select number of Pacific Northwest and Intermountain Western states to study, among other things, natural resource and environmental law, because you could do that up there at the time, and ended up going to the University of Idaho and was able to, get a good exposure to water law, environmental law, hard rock mining law, forestry law, et cetera, and was able to, translate that into a position at the Idaho Attorney General's office representing the state water agency up there, the Idaho Department of Water Resources. And then I'm going to cut out a lot of the next 20 years of my career winding through various, Texas Water Commission, International Boundary and Water Commission. Had my own law practice out in El Paso, and then joined the firm of Kemp Smith in 1996. And the Edwards, of course, was a huge issue in the 90s. And while I wasn't part of it when I was in El Paso, I certainly was aware of it as a water law lawyer. You could not be aware of the Edwards back in the 90s. And so I was actually asked to come over here in 96 to kind of give an outsider's view on the Edwards Aquifer Authority Act.
Okay.
To actually, I believe it was the San Antonio Greater Chamber of Commerce, which led to me applying, and then I found out that the position of general counsel was open. This was in the September, October timeframe of 96, and applied, threw my hat in the ring, and gosh, lo and behold, I end up getting it.
It seems kind of serendipitous, like the fact that you came here and then it was open, right?
It's totally serendipitous. And then here it is 27 years later. It's kind of remarkable to think about, but it's not the kind of thing you could, put together and make a plan for.
Yeah.
Just as you say, it's something that came up and seems to have worked out.
Yeah.
Most definitely, and we're glad you're here. So speaking of the EAA, we kind of wanted the story of the EAA from your perspective. It's certainly unique as far as aquifers go and groundwater goes and how its story goes. So we wanted to hear that from your perspective.
Well, sure. Yeah. So, the EAA, of course, is the successor agency to the Edwards Underground Water District, which had existed since the 1950s. 1950s drought, it was created. So, but specifically with regard to the Edwards Aquifer Authority, I think we all know that the EAA, while the EAA Act had been passed in the 1993 legislature, various legal issues prevented it from being coming into existence, primarily Voting Rights Act issues. And it wasn't until June 28, 1996, when the Texas Supreme Court issued its famous bar shop opinion validating the creation of the Edwards Aquifer Authority Act, and thereby the dissolution of the Edwards Underground Water District and the creation of the EAA. And so, that of course was the watershed moment, no pun intended, vis-a-vis the EAA. And at that time, the EWD staff became the Edwards staff, and a new board, the EWD board, was dissolved, and the EAA board, which was a temporary board created by the legislature, became installed at that time. But these, relative to the story of the EAA, I think it's fair to say that the EAA was given what I think arguably the most difficult job ever in the history of Texas water law, which was to do something that had never been tried before, and that was adjudicate the groundwater rights in the Edwards, issue permits to those who had presented sufficient evidence to qualify for a water right, to then manage and regulate the aquifer under the terms and conditions of the EAA Act. This also involved the creation of an Edwards water market, which came into play after the permits were issued, and then finally to do all of that in compliance with the Endangered Species Act. That this had never been attempted in Texas before, and was utterly at odds with the prevailing views of landowners at the time, that they had a common law right to withdraw groundwater from the Edwards whenever they wanted, in whatever quantities they wanted, without regulation by the government, and that right was constitutionally protected and could not be abrogated. And this was a long-standing and strongly held view in the landowner community, not just in the Edwards, but across Texas and in general. And, this view was not an unreasonably held view because, again, there was another famous Texas Supreme Court opinion issued in 1904, the Houston and Texas Central Railway against East case, which had established the common law rule of capture right, wherein for landowners, groundwater in Texas, and the language in that case was pretty strong. This common law rule of capture right had become deeply ingrained and embedded as a right landowners had, but after you read the Edwards Aquifer Authority Act passed by the legislature, it doesn't really look very much like the common law rule of capture.
It does not, and that was followed up in the 70s from another ruling, right, where they ruled that groundwater was too mysterious and occult to be regulated at all.
Well, yes. Yeah, that's absolutely right, which, of course, we know now it's not mysterious and occult. And especially the Edwards, as much time as we've spent studying the Edwards, it's becoming less occult, less mysterious. It still has mysterious qualities to it. But so the mission under the EAA Act was very different than the Texas Common Law of Groundwater, and the assignment given to the EAA was, as you might imagine, fraught with legal and political peril, which honestly, at the time, it looked like a recipe for failure, honestly, because they were so at odds with each other. So but looking at it, so the story of the EAA, the EAA took this mission, and it, a lot of people maybe thought it was going to fail in accomplishing that mission. But, having been there on the ground, I think we can say the EAA has exceeded expectations in its administration of the EAA Act and the transition from the common law over to a statutory-based permit system under the Act. And I would say the EAA story is, a job well done under very, very difficult circumstances.
Wow. Mm-hmm. If the EAA didn't exist and didn't succeed, where would we be now?
Very, very good question. I've talked to the board about this at work sessions from time to time over the years. But so there's a limited number of entities that could have managed the Edwards or managed, regulated, whatever word we want to use. One could have been state courts.
Okay.
Which is essentially what the common law rule of capture was, management of an aquifer or the non-management of aquifers by state courts, if you will. We could have had Judge Bunton take over the aquifer in the first Sierra Club lawsuit. He was out in Midland, and he threatened from time to time to take over the management of the aquifer if somebody didn't.
That's right, federal oversight.
So,
interesting.
Then there was also briefing in that case about whether U.S. Fish and Wildlife could take it over under the Endangered Species Act. So are they going to manage it? Mm-hmm. Or is Judge Bunton going to manage it? Or is the Texas Supreme Court going to manage it? Or is, at that time, we had the Texas Water Commission. Were they possibly going to manage it? Which, as we know, they tried to do by declaring the Edwards to be an underground river in I want to say 1992, after the Sierra Club lawsuit was filed, and of course, by claiming it's an underground river, it took on the quality not of an aquifer but of surface water, which the Water Commission had jurisdiction over, and of course that was very short-lived. Those rules were overturned very, very quickly. So if it hadn't been the EAA, well, and I forgot, the EUWD was still around.
Yes.
So, the EUWD had some regulatory authority, although it seemed like it was primarily a research agency, but it did have some regulatory authority, although you had observers of the EUWD that claimed they didn't have such authority or that the authority was too weak to get the job done. So those are the entities that could have potentially regulated the Edwards if the EAA hadn't been created.
And so they took, like you mentioned earlier, the EUWD, which was comprised of hydrologists and geologists, like we kind of had talked about. So they were they knew the inner workings of the feature itself, which is the Edwards Aquifer. But then, like you were mentioning, then you had to bring in the regulatory component.
Yeah, they didn't specialize in administration or regulation. They were scientists and then asked to regulate the aquifer.
Mm-hmm. Yeah, I think that's a fair statement. Yeah.
Wow.
Yeah, I think that's fair.
So Darcy, we talked about you've spent 27 years here now as general counsel to EAA. Can you talk a little bit about that and how it makes you feel to have that legacy here at EAA?
Wow, old? No, surprised maybe some of these words come to mind. Certainly grateful for the opportunity and thankful. So I certainly feel grateful and thankful for those 27 years. But, as an attorney, especially in environmental law, water law, and so forth, but generally you're always hoping to do something, I guess, that makes things better for people, and, so certainly grateful. I had a pre-Edwards legal career, and I had worked on some, pretty, very, very interesting issues over my 44-year legal career, when I was up in Idaho, wilderness issues, interstate salmon issues. We implemented the War on Energy, President Carter's War on Energy back in the 70s. Later got involved in low-level radioactive waste management issues, surface water, groundwater adjudications. I worked on the colonias on the border, water districts on the border. I've done a lot of interesting things, but I don't think there's any doubt the Edwards will certainly go down as the highlight, of my career. But no, I'm just, truly grateful the board selected me and us back in '96 to do this work. And
you were mentioning Kemp Smith is the second oldest law firm
in Texas.
Right. It was created in 1866.
That's so fascinating.
And it's it's remarkable that something has lasted that long. Yeah.
So you mentioned, Darcy, how tenuous things were at first. Everyone was sort of at odds with each other, yet they had a common goal, which was to preserve the aquifer and sort of make sure that Texas remained in charge of it. Mm-hmm. And you were a big part of that. So I kind of like to get your perspective on how you've seen the EAA change over time. When you started here, there must have been 20 or so employees, 25 employees, and now we have over 100. We've seen the Endangered Species Program progress and mature to the HCP. So you've seen a lot.
Well, right, yeah. As I mentioned earlier, the EAA inherited the EWD staff on June 28, 1996, which, as I mentioned, was primarily a research agency. So the staff that the EAA inherited kind of matched that particular mission. Now, and it was small, as you said. So while, the EAA, of course, continues to have a research mission for the Edwards, and we have a nice complement of folks here that do that. The legislature gave us a very different mission in the EAA Act, and that was to regulate and manage withdrawals from the Edwards for the benefit of the federally listed threatened and endangered species, which is, regulation in Texas has it's kind of a bad word, but, we were given the job of regulating the Edwards in a way that was different from a common law rule of capture. And so, we had to, the Edwards had to kind of shift, I think, its mindset and staffing and, systems to move from a research agency to a kind of a regulatory agency. And so I would say, relative to how the EAA evolved over time, so, there's been maybe three big phases of the Edwards. The first phase was, I would say, from 1996. Of course, that was a startup mode, but 96 to 2008, that's kind of what I call the permitting phase, where we were adjudicating. I'm using the word adjudicating. We didn't technically adjudicate the rights because only courts can do that, but we did administrative findings on who qualified for permits or Edwards water rights, so the permitting phase, 1996 to 2008, so the agency grew quite a bit during that period because that was not easy. It took a lot of bodies, took a lot of legal processes and process and procedure and administration to identify those water rights, get the applications in, process the applications, work through the decision-making process, and that, in my opinion, that ended with that final order that we issued in August of 2008, proclaiming all of the water rights permitted amounts after the 2007 legislative session when Senate Bill 3 was passed. So that was kind of phase one. Now, it's true we also have this endangered species mission, and it's not like that wasn't being worked on during that period. So I think you could say there's kind of a phase 1A from 1999 to kind of 2005. We were working on an HCP at the time, but there were too many legal uncertainties about the permitting program to allow that HCP to actually.
You kind of needed the one finished before the other one.
Right. So, that was that effort was overlain. Is that a word? Overlain over the permit program. But the main focus, of course, was permitting.
Yeah. And
then fortunately, the legislature in 2007 passed Senate Bill 3, which did two things. It removed all the legal log jams that had existed under the permit, some of the permitting sections under the EAA Act. It cleaned those up so that the EAA could move forward and finalize the permitting program, which it did in 2008. But then, of course, it created the ERIP process, Edwards Aquifer Recovery Implementation Program, with very, tight deadlines. So the EAA wasn't able to kind of just, work on this over time. It had a defined period of time from 2007 to 2011 to get this done. So that's kind of, in my opinion, phase two. That the ERIP program from 2007 to 2000, and depending on, ERIP technically ended in December of 2011 and kind of carried over a couple of years till Fish issued the ITP in March of 2013. That, in my opinion, that's kind of phase two. Then and now we're in a new phase 3. I'll just call it the Next Generation Initiative. Which is, I'm not sure what the exact start date of that is, but it's been around for 3 years, maybe something like that. And each time the Edwards has kind of had to. Again, it's not like the permit program has gone away. It's morphed over into what I'll call the Edwards water market, where we're administering the permits. That's still there. We did get our ITP, so the species protection mission is still there. And then this new next generation mission. So, what the Edwards has been able to do is, depending on the focus, it's been able to do two things. One, get its arms around what the main mission was, match the staffing to get that job done, and then get it done, and then shift to the next new thing, or new, not necessarily new, but the next thing that needed to be done. So that's how I see the EAA having evolved over time. The level of expertise here at the agency, again, far exceeds what it was in 1996. As of course, people come here, they stay, they learn their job, particularly in the permitting program and the HCP and all the other disciplines that the Edwards needs to function as a, high quality regional groundwater conservation district. So I would say that's kind of what I've seen over the years.
Yeah, very well put.
And being here for, 27 years, like we've talked about, and I know you kind of mentioned this before, but do you have a sense of personal legacy? I mean, you will go down in history books, like you will, with all the things that you've done and worked on for the EAA.
Well, that, again, a very good question. So I kind of alluded to this earlier. Lawyers are always looking for ways to make a positive impact on people's lives. Specifically as a water lawyer or an environmental lawyer, you're involved in the use and utilization of natural resources, and you'd like to hope that your legal efforts are consistent with, fostering wise and prudent and appropriate use of these resources, not just some outcome that benefits a client, let's say, but that's really benefits the general welfare of the public and the environment. You know, you'd like to think that. You know, there's one of the things about this position is because, as I stated earlier, the EAA Act and the radical transition from the common law, Texas common law of groundwater, because they were so much at odds with each other. I think there was a need, to be expansive and have a balanced view of what that transition should look like, and in order just honestly to be fair to everybody, because it was such a major change and people were being affected, you know.
Yes.
So just attempting to find a fair and balanced solution for the environmental community, for the permittees, the irrigation interests, the urban interests in Bexar County, the downstreamers, you know, trying to come up with legal systems and legal solutions that attempted to be fair to all of those, and at the same time be faithful to and follow the EAA Act. You know, we have to do that. So, I guess, personal legacy, I hope, whenever I end up moving on to something else, that I will have left the region in a better condition water-wise than, when I got started on this, because it was so contentious back then and everything was uncertain. I'd like to think, I've left the region with a higher level of certainty about what the legal system is and what their rights and duties and obligations are, and that those systems that we helped put into place survive the test of time and actually work. So, if that can happen, then that would be kind of legacy I would, modestly hope that I had some participation in.
Most definitely. Yeah. I think the Edwards Aquifer is just another example of how a water issue can actually bring opposing parties together as opposed to making things worse. We often hear that water is for fighting, and there's that, ongoing examples of where the opposite is the case, and I think you've been a big part of that, Darcy.
Well, thank you. I'd like to hope so.
Yes.
I've certainly tried to be.
Yeah. And I think it's amazing to see your trajectory and the various things that you've accomplished and done, because you said you got started when the environmental movement was just, starting, and then you became that, and you did something. You did something memorable for all of the people that rely on the Edwards Aquifer.
Well, thank you for saying that. God, that makes me feel good. Thank you.
Okay, Darcy, 27 years. What is your most, if you can limit it to one thing, what is your most memorable moment of your career here?
Right.
So
well,
far?
I would say of all the questions you've asked, that may be the most difficult one. A few years ago, for one of the board work sessions, I did something that it's called Darcy's Top 25 Edwards Legal Events.
I like that.
So I pulled that out and kind of reviewed that. I mean, like I say, it's not an easy question, because we've won some momentous big-time lawsuits, and, we've passed some momentous big-time rules and put in some, administrative processes that make sense. But, if I had to say one, I would say, in most memorable event, I'm equating that with most significant consequential legal event.
I would agree with
that's
that.
what I mean by that. I mean, I could say, I would say it was the passage of Senate Bill 3 in 2007, because prior to that, our permitting program was stymied by this acre-foot cap because we had more permit amounts to issue than that, and that was a huge legal logjam. And there were some other uncertainties in the act that needed cleaning up. And so when Senate Bill 3 was passed, we were able to finish the permitting program, as I mentioned, in August of 2008. So that was huge.
And is that when it changed to 572,000 acre feet?
Right,
Okay.
right. And then secondly, because we were able to finish that, the legislature could kind of force or, create all these deadlines to get the ERIP program going and get the incidental take permit issued, which created the legal certainty for the management system for the Edwards relative to the Endangered Species Act, which is what started all this to begin with back in 1989. So those two things, provided a workable path forward to remove the log jams that had been impeding us from really finishing the job that the legislature.
Yeah, that is huge.
That is.
So I would say Senate Bill 3 certainly would be way, way up there. Just stepping back and in terms of just more generalized, memorable moments, just all of the amazing relationships and friendships here with the board and staff and, observers of the Edwards and folks that interact with the Edwards, just the amazing set of people that I've met over those years. I would have to say that as being a memorable, but those are non-legal memories. But in terms of the most memorable legal event, Senate Bill 3 would have to be on that short list. Yeah.
All right. Yeah. Well, Darcy, we certainly appreciate your time being with us. It's not often we get to talk with somebody who's had so much experience with the Edwards over time. We know about these issues, but we weren't there, and you were. So it's great to provide that to our listeners, a firsthand perspective, starting really almost from the beginning of the story of the Edwards. So thanks again for joining us today.
Well, my pleasure. I hope it was helpful.
Yes, it's been great.
Definitely. We'll catch y'all next time.
Thanks for tuning into this episode of the Recharge Zone podcast. Have questions, ideas for topics, or things you would like to share with us? Well, reach out to us at rechargezone@edwardsaquifer.org.